Hi everyone, this is a quick overview of Indian Evidence Act 1872. So, the meaning, evidence and the meaning. The truth is believed to be the mother of justice. The court decided cases based on the evidence on record. The right of the parties are to be decided on evidence which is relevant and admissible. The law of evidence plays an important role in the functioning of the judicial system. The Indian Evidence Act 1872 applies to all judicial proceedings before a court of law. All law can be divided into two, that is, substantive law and procedural law. The substantive law deals with the right and liabilities of the parties. The procedural law deals with the means whereby rights and liabilities are established. So, substantive law can be of civil law and criminal law. The civil law deals with the rights and duties of individuals. It provides remedy in case of breach. For example, Hindu law, Muslim law, law of contract, law of torts, etc. Now, criminal law. The criminal law defines the offences. It provides for the necessary punishment. For example, Indian Penal Code, the Dowry Prohibition Act, etc. Now, procedural law. The procedural law lays down general principles of jurisdiction and the power of courts. It prescribes the procedure, the manner, and the mode in which the jurisdiction may be exercised. For example, the Criminal Procedure Code provides the procedure for investigation and trial of the criminal cases. The Civil Procedure Code provides the process to be followed by the civil courts. The law of evidence is a procedural law, and its main object is to consolidate the rules for regulation of the judicial proceeding. Now, development of law of evidence. The law of evidence prescribes the procedure for the following problems. First one, the law of evidence prescribes what facts can be proved in a court of law. It allows only material and necessary information in order to make a just decision. This means only relevant facts to a particular dispute may be proved. And the second one, evidence is nothing but persuasive and pertinent information presented before a court of law. It can either be a way of a testimony of the witnesses and through the content of the document. Now, the third one is the judge, while considering a disputed fact, has to assess the oral and documentary evidence as also the attendant circumstances. He has to separate the grain from the chaff to draw the correct inference in order to come to a just conclusion. And the fourth one, the evidence is appreciated in the light of the general principles of jurisprudence and natural justice. So, to summarize it, and the important note with respect to law of evidence is that the accused is always presumed to be innocent until his guilt is established. The prosecution must prove the allegation beyond all reasonable doubt as regards the guilt. The benefit of doubt shall go in favor of the accused. A mere suspicion is not proof enough. The accused should not be condemned unheard. There is a saying that let 9 guilty persons go unpunished, but not one innocent person shall be punished. Now, the basic principle of law of evidence is that the evidence must be given as to the matter in issue. The second one, hearsay evidence is no evidence. And the third one, the best evidence must be given. So, these are the basic principles. And with respect to hearsay evidence is no evidence, there are exceptions in certain circumstances. That is an exceptional rule. Now, safeguards to ensure the sanctity of evidence. The first one, giving false evidence or fabricating false evidence is an offense. So, we are discussing safeguards to ensure sanctity of evidence. The first one, giving false evidence or fabricating false evidence is an offense. The evidence should be given on oath or in affirmation in judicial proceedings. The person tendering evidence must be a competent witness to depose. Now, the court can reject the evidence of unreliable persons. Evidence is subject to scrutiny of cross-examination. The Evidence Act applies to all judicial proceedings before any court or court-martial. The Evidence Act does not apply to affidavits, proceedings before arbitrators. Once again, Evidence Act applies to all judicial proceedings before any court or court-martial, but it does not apply to affidavits and proceedings before arbitrators. The tests to find out the applicability of Evidence Act to any proceedings are: 1. Whether the proceeding is a judicial proceeding or not. Second, whether it is before a court or not. If the answer to the above test is in the affirmative, then the Evidence Act applies to such proceeding. So we discussed about judicial proceeding. What is judicial proceeding? Judicial proceeding may be understood as any proceeding in the court wherein evidence may be legally taken on oath. Now, it is a proceeding in which any judgment, sentence, or final order is passed on the basis of recorded evidence. Thus, an inquiry in which evidence is legally taken is included in the term of judicial proceeding. Now, court. The term court has been defined under Section 3 of Evidence Act as all judges and magistrates and all persons except arbitrators legally authorized to take evidence comes under court. All judges and magistrates and all persons except arbitrators legally authorized to take evidence is the meaning of the court as defined in Section 3 of Evidence Act. Now, sovereign judicial power must be conferred on the court by a statute to decide the right of the parties in a definitive judgment. The parties are entitled to certain rights in a court, and they are the following. The first one, the right to be heard in support of their claim. The second, the right to adduce evidence in proof of their claim. And the third, the right to decide the matter on consideration of evidence. Now, tribunal. The Evidence Act becomes applicable to the proceedings before the tribunal only if the statute creating the tribunal authorizes it to take evidence. The applicability of the Evidence Act to the tribunal depends on the power conferred on it by the statute under which it is established. Now, arbitrator. An arbitrator is a person who is chosen by the parties themselves to settle the dispute. Such a person need not be well versed in the law of evidence, but nevertheless he is bound to follow the principles of natural justice. In short, the Evidence Act is not applicable to the proceedings before an arbitrator. Estoppel. Estoppel is discussed in section 115. When one person has by his declaration, act or omission intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. So the key elements here is when a person has by his declaration, act or omission. So there is a declaration, act or omission. And what happens with this? Intentionally caused or permitted another person to believe a thing to be true. And with this belief, that person was induced to act upon such belief. In that case, neither the person or his representative can deny this fact when there is a suit between the person who made him believe and the person who acted on that belief. So that is with the doctrine of estoppel. Estoppel is defined in section 115. Section 115 of Indian Evidence Act 1872. For example, A intentionally and falsely leads B to believe that certain land belongs to A. A thereby induces B to buy and pay for it. The land afterward becomes the property of A. A seeks to set aside the sale on the ground that he had no title at the time of the sale. A must not be allowed to prove his want of title. So, at the time of sale, A did not have the title, but subsequently after the sale, he got the title. The sale was performed when A made B believe that he had the title, and the sale was carried out. Later, subsequently, A got the title, so he cannot deny that when he made the sale, he did not have title. So that is estoppel. Now, doctrine of estoppel. A man's own deed is a complete estoppel to an averment in a contradiction to it. It is based on public policy to prevent uncertainty and to establish truth. The object of this doctrine is to protect the interest of the person who acted believing the statement of another. So the object of doctrine of estoppel is to protect the interest of the person who acted believing the statement of another. The doctrine of estoppel is based on three moral principles. The first one, no one can blow hot and cold in the same breath. The second one, no one can take advantage of one's own wrong. Third one, no one can approbate and reprobate at the same time. So, the three basic moral principles of doctrine of estoppel. The first one, no one can blow hot and cold in the same breath. Second, no one can take advantage of one's own wrong. Third, no one can approbate and reprobate at the same time. If there is a declaration which induces another person to believe it to be true, and if he acts upon the belief, the declaration or statement cannot be allowed to be taken back. The elements of estoppel are: first one, representation or declaration. That is, he makes a declaration or makes another one to believe. Now, second one, with the intention of inducing another person. And the third, the other person has believed and acted upon it. And the fourth one, prevention of denial. So the four elements of estoppel is: the first one, representation or declaration; the second, the intention of inducing another person; the third, the other person has believed and acted upon it; and the fourth, prevention of denial. Now, there are three kinds of estoppel, that is, estoppel by record, estoppel by deed, and estoppel by conduct. Estoppel by record. Estoppel by record normally refers to judgments or public records. Estoppel by records normally refers to judgments or public records. It is the general belief that public record is a final and conclusive against persons. Estoppel by record shall have authoritative force because of legal sanctity. Now, estoppel by deed. Estoppel by deed means estoppel by agreement or covenant. It is based on the principle that when a person enters into an agreement, he shall not be permitted to deny his statement. Every person is bound by the recitals in a deed to which he is a party. The wholesome principle of morality and equity is emphasized. To take advantage of estoppel by deed, the following conditions must be satisfied. The first one, the agreement must not be illegal or induced by fraud. The second, the agreement must be in unambiguous terms. Third, there must be possibility of specific performances in the event of breach. Now, the third category is estoppel by conduct. That is, estoppel by conduct is also known as estoppel by pious. If any person, by words or deeds or acts, causes another person to believe the existence of a thing and he acted upon it, the person who induced is stopped from denying the existence of the thing. So, here we have a relevant case law, that is Pratima Das versus State of Orissa, AIR 1975. Pratima Das versus State of Orissa, AIR 1975. The candidate was selected for admission to the MBBS course on the basis of the marks obtained in the competitive examination. She joined MBBS course after leaving another course which she was doing. Subsequently, her admission to MBBS course was cancelled on the ground that some other candidates obtained higher marks. Due to the lapse of time, she was unable to rejoin the course which she had abandoned. Here, the court held that admission to MBBS course, once granted, cannot be called off on unreasonable grounds. The authorities were held stopped from the cancelling the allotted seat. The doctrine of estoppel by conduct was applied in this case. That is Pratima Das versus State of Orissa, AIR 1975. Now, we also have promissory estoppel. The doctrine of promissory estoppel has been evolved through equity and to avoid fraud and injustice. The following conditions must be fulfilled. The first one, there must be a promise to do or not to do something in the future. The second, the promise must have been made with an intention that it should be binding on the promiser. The third, the promisee must have acted upon the promise of the promiser. And the fourth, there must be change in the promisee's position. So these are the 4 conditions to be satisfied with respect to promissory estoppel. There must be a promise to do or not to do something in the future. The promise must have been made with an intention that it should be binding on the promiser. The promisee must have acted upon the promise of the promiser, and there must be change in promisee's position. So we have few case laws here, that is Nagarmal Mahavir Prasad versus the manager, United Bank of India, AIR 1987. Nagarmal Mahavir Prasad versus the manager, United Bank of India, AIR 1987. Here, the court held doctrine of promissory estoppel is certainly an equitable doctrine. It can only be applied in a case where there is no concluded contract but promise has been made by one party intending to create legal relation or legal effect, legal relationship to arise in the future, and other party has acted upon such promise or representation and changed his position, or that the other party relying on such promise has acted to its detriment. So this is held in Nagarmal Mahavir Prasad versus the manager, United Bank of India. Please note, the court held that it is to be applied in a case where there is no concluded contract but promise has been made. Now, the next case law is Ashok Kumar versus Union Territory, AIR 1955. Ashok Kumar versus Union Territory, AIR 1955. Government initially granted a permit for cement. Later, the permit was cancelled on account of change in policy. The court held no promissory estoppel in the case of change in government policy. So, here the court held no promissory estoppel in the case of a change in government policy, and that was held in Ashok Kumar versus Union Territory, AIR 1955. Another case law, Bajrang Industries versus the General Manager, AIR 1994. Bajrang Industries versus the General Manager, AIR 1994. Here, the promise made by the public authorities was beyond their power. Here, the court held no promissory estoppel in the case of representation by public authorities beyond their power. Once again, court held that no promissory estoppel in the case of representation by public authorities beyond their power, and that was held in Bajrang Industries versus the General Manager, AIR 1994. Then we have Bharat Wools versus Ludhiana versus State of Punjab, AIR 1996. Bharat Wool Ludhiana versus State of Punjab, AIR 1996. Here the court held promissory estoppel cannot be invoked on mere invitation. So the court held promissory estoppel cannot be invoked on mere invitation. That was held in Bharat Wools Ludhiana versus State of Punjab, AIR 1996. Then we have Gopi Chand Television versus Doordarshan Kendra, AIR 1995. Gopi Chand Television versus Doordarshan Kendra, AIR 1995. Here the court held promissory estoppel cannot be invoked on fresh proposal or subsequent offer. Once again, court held promissory estoppel cannot be invoked on fresh proposal or subsequent offer. So, the case laws we discussed here is with respect to estoppel is Pratima Das versus State of Orissa, AIR 1975, where the admission to MBBS case was held, and the court held that the government is stopped by the conduct of allotting the seat. And then we have Nagarmal Mahavir Prasad versus the manager, United Bank of India. Here the court held that even when there is no concluded contract, there is a promise, and this is done with the intention to create legal relation or legal relationship, and thus they are if the person has acted on such belief, the authority, the bank, is bound by doctrine of estoppel. And then the next case law is Ashok Kumar versus Union Territory, AIR 1955, where it held that no promissory estoppel in the case of change in government policy. It was related to the policies regarding cement manufacture. Now, Bajrang Industries versus the General Manager, that is AIR 1994. In that, it held that no promissory estoppel in the case of representation by public authorities beyond their power, And in Bharat Woods Ludhiana versus State of Punjab AIR 1996, the court held that promissory estoppel cannot be invoked on mere invitation. And Gopichand Television versus Doordarshan Kendra AIR 1995, here it was held that promissory estoppel cannot be invoked on fresh proposal or subsequent offer. So that is with the estoppel and kinds of estoppel with respect to the relevant case laws, and the estoppel is discussed in section 115. That is with this part 1 of quick overview of Evidence Act 1872. The rest will be carried in the following parts. Thank you for listening. Stay tuned. Like, subscribe and comment. Click the bell icon so that you can get the update when I upload the next video or the next part of this. Thank you.